Hi everyone, my name is Paula and I am a law student in the Indigenous Law program at UVic, and I've been helping SIIA, the South Island Indigenous Authority, for about 2 years now with some of the legal drafting work that's been going on. And I am here today to talk about Section 6 of SIIA's draft law, which is the application section. So right off the bat, the application of the law section indicates that the law applies to A, the children and family of all member nations wherever they may live, and B, all Indigenous guests within the member territory. So of course this means that members from Pachidat, Sauk, Chenu, Eswaimalt, Songhees, Sartlip, and Sekam are all people to whom this law applies. And the law applies wherever they may reside, so it also applies to off-reserve members. SIIA is an Indigenous governing body, and Indigenous governing bodies, or IGBs, throughout Canada are currently creating their own laws to deal with child and family well-being. And so what actually sets SIIA apart from all other IGBs in Canada is that we are taking an approach that doesn't only correspond with the membership of the IGB, but also with the traditional territories of the member nations. So this is where Section 6.1.1 sub B comes in, which is that this law applies to all Indigenous guests that reside within the traditional territories of the member nations. And so this is kind of a unique approach that SIIA is taking, and it's grounded in the principles of the guest-host relationship, which really draws on long-standing customs and legal principles of the South Island nations. In the 7 member nations, the act of hosting is deeply significant. When guests enter the territory, the hosts take on the responsibility of ensuring their well-being, and guests are expected to respect the laws and protocols of the nation whose territory that they're on. And we've heard this a lot from community members that everything within the longhouse is under our care. And so we see the member nation's territory as a metaphorical longhouse, and everything within the 4 posts of this longhouse is under SIIA's jurisdiction. And so, like I said, this is unique because it means that someone like a member of a Cree Nation or Anishinaabe Nation who lives in the territory of the Coast Salish people, so in Victoria, would actually fall under SIIA's jurisdiction. And this also applies to non-status members. So if there is a Indigenous person who is entitled to be registered to a nation anywhere in Canada, SIIA's law will apply to them as well. So in the process of creating a law that applies to Indigenous guests, we've actually done a lot of outreach and engagement with Indigenous guests living in the member nation's territory. And we've heard some concerns from them regarding the fact that a law may apply to them that does not necessarily adhere to their own cultural practices or protocols or laws. And so we've decided to explicitly add a provision within our law that states that if another Indigenous governing body has a law that applies to an Indigenous guest, then that law will prevail to the extent of any conflict or inconsistency between that law and SIIA's law. And so SIIA is essentially taking on the role, the current role of MCFD, of the Ministry of Child and Family Development. And the member nations believe that SIIA is in a better position to coordinate the services of Indigenous peoples in this territory than the provincial government is. And we've also decided to enshrine this principle within our law called Jordan's Principle, which was initially developed in the context of jurisdictional disputes between the federal and provincial governments in Canada, but we've kind of reconceptualized it as a way to deal with negotiations of jurisdiction between SIIA and other Indigenous governing bodies. And so this means that any kind of jurisdictional overlap issues will not result in a gap, denial, delay, or disruption of services to a child or family in need. And this means that right up front, these services will be provided when that family is in need, and then anything related to those jurisdictional issues, such as funding or other things that need to be negotiated between SIIA and another Indigenous governing body, will be done after the services are provided. And so this is just to ensure that these types of really complicated jurisdictional regimes don't result in a bunch of Indigenous children and family not receiving the services they need when they're in a crisis situation. So lastly, Section 6.3 of SIIA's draft law deals with the coordination of services between SIIA and other Indigenous governing bodies, as well as child and family service providers. So other child and family service providers includes entities such as the provincial ministry, as well as existing delegated Aboriginal agencies. And this section really just outlines the process for entering into agreements regarding the coordination of service provision. And it actually explicitly allows or enables SIIA to enter into agreements such as, for example, memorandums of understanding with other nations or Indigenous governing bodies that may have lots of members living within the member nation's territory. For example, maybe Kwakwaka'wakw nations or Nuu-chah-nulth nations may have many members living within urban spaces within Victoria, and may want to enter into these proactive agreements with SIIA to sort out the funding and delivery of services to their members before there's sort of a crisis situation that arises. Additionally, this section kind of ensures that if another child and family service provider intends to provide services to an Indigenous person who would otherwise fall under SIIA's jurisdiction, they're kind of required to notify SIIA that they are doing so that no one's falling through the cracks, and SIIA is able to take inventory of, who is providing services and ensuring that everyone is being provided adequate services within their territorial jurisdiction.